he's looking for a lawyer. No, he's not looking for a lawyer. He's just looking for some answers. He may think that the lawyer's the answer, but maybe it's another answer like, oh, don't do anything. You can wait. This isn't a crisis for these reasons. Here's some self-help. And he just saved him $10,000, $15,000. Or maybe it needs to be done by a lawyer and they don't have the money to do it. And we can refer him to somebody that may be more affordable, or to a video that describes how to solve that problem.
I feel better about it. Like, you actually took my advice, because I'm helping you out one day. You need help with your whole life.
I think we need to train pro se litigants on how to leverage ChatGPT, like how to describe your problem. It's always got to be, you can't trust it unless a lawyer signs on. But man, they got nothing else. I mean, they're turning to whatever they can find for help. So why aren't we teaching pro se litigants on how to leverage AI to prep for trial? I'd like to see more lawyers putting out like video content on their strategies, because a system that's created to give people due process, but there's not a system of making process literacy.
I might say what I know about your case, and then say, now I've done too much talking. Did you have specific questions that you wanted to ask me today? If I'm giving them the knowledge and awareness I know about their case, that I have access to things filed and I've prepped to speak to you, not to waste time, and so that you feel understood and heard. And I let you speak, let you ask questions. It just depends on each person. You got to feel it. It's a art and a skill based on life experience and time doing this, that you can read people and give them what they need. Consultation is more than giving them legal advice.
That's the point that I think a lot of lawyers miss about the purpose of a consult. They make it too salesy, or they try to take what they think the person should want to hear and make them hear it. I see the nuance in that. So what people are wanting to hear versus what we think they want to hear is what they really need to hear. Like, we know what they need to hear, but you can't just tell them what they need to hear when they're not ready for it. Because usually they're wanting to tell you a story. Everybody wants to be heard.
They do. And
because they're coming to you with a need. I think if you really break down the customer journey, for most people searching for attorneys, like what do clients want? Well, they want answers. They want to feel safe. They want a plan, and they want somebody to help them. And that starts from the minute they've got a crisis going on, right? The customer journey starts with what they know. Like, maybe they've been sued, like somebody came knocking at their door, handed them a complaint, and they get like an adrenaline rush and cortisol. It's like probably not 10 o'clock at night. When do they usually serve people?
It's probably a cutoff, probably 9 o'clock, like creditors, I would say.
Okay, so the process server shows up at the door, pizza in their hands, hands them an envelope or a stack of papers, and they look at it and they get that terrible feeling. Or they've known about it for a while and they know something's about to happen, and they start looking for help then. Or police officer knocks at their door, or there's a huge conflict and someone comes. So it's either like a family member calling, or it's the client, the potential client.
People want to be heard. They need validation about their concerns and fears or desires. Maybe they're the ones who need to sue or defend themselves. And they need reassurance that they came to the right person who's going to take their problems off their hands and make it their own problem to help solve. Take their chaos and make it orderly without the emotion built into it, and using our systems and tools to create that weapon for defense, for trial, for attack, to get the desired outcome if it's a reasonable outcome. And after strategizing, and we all come together as a team, and they're the main part of that team, and we can all agree at an end result. Yeah. We just sharpen our tool and focus our energies to accomplishing that without the emotion that they come to us with. We take their headache so they can sleep at night.
I think every lawyer is a defense lawyer. I think prosecutors are defense lawyers. I think plaintiffs' lawyers are defense lawyers. I think everybody comes to a lawyer to be protected and defended. Just like national security is, we call it defense, we call it the War Department now, but It's peace through strength. That's what everybody wants. They want to be at peace, and the best way to do it is to become stronger. And be alone, walking around out in the woods, wandering the world with a legal problem is just as terrifying as being in the Arctic tundra, with a bunch of fish oil all over you, walking around polar bears. I mean, there's just no safe feeling in weakness, and so people want to be strong.
And strength comes from training and discipline. If you're into sports and you played sports, you understand that some people have some natural talent, but a lot of people have to work at it, repeat it. My coach was way ahead of his time. He would have us visualize the steps that we were taking. And years later, that was new science, that people who could visualize the end goal and the steps it took to make a basket or a touchdown or a block could accomplish it. But it also takes muscle memory, repetition. And another thing we would say is your competition may be working 5 minutes longer than you in the gym or in the office. That's where you're going to find us getting up early, staying late, and working weekends and holidays, because there's strength in preparation and muscle memory. This is not something that, just comes off the tip of your tongue, although it can because of our age and wisdom and repetition. Each individual case and facts is what we have to work on, and the strategy, who our opponent is, and who our decision makers are make a difference. So we have to prepare for different options, plan A, B, C, and D, contingencies. We got to work through those. So like you say, we need strength, and I'm just reiterating, strength comes from that discipline and focus.
I think even a brand new lawyer can be a very good lawyer and have lots of experience in their head. Like, they can be sitting around gaming the case out. Okay, this is said, then what's the most likely thing the witness is going to say next? And then what's my most likely objection? What if somebody else objects to this, or what if this comes in? The what ifs are the preparation. Like, if you go to trial and you're trying it for the first time, then you failed. I mean, obviously you can do a focus group. You can do like what we do here. We do a lot of mock trials where we bring in whoever will come, right? Pay them $100, pay them whatever the temp service rate is. People love it. It's enjoyable to them. They give us real-time feedback. But we're our best critics, and you're running through everything that can go wrong in the case. So when you go to trial, you're not surprised. Now, I think there are great orators that can say the best things, that are very well spoken. I'm just not that person. I've got to have an opportunity to know what the best thing to say is, and I'll maybe get a close approximation to that when I'm speaking in a closing argument. Like, I write out my closings. I write out my openings. I write out my jury questions, and maybe I glance at the potential jury questions, make sure I don't miss anything substantive. But how often in closing are you reading something? Like, never. But if you're going to have a good closing, you have a higher likelihood of a good closing if you already wrote what you thought would be the best possible closing. And then, the Holy Spirit gets in you, or flow state gets into you, you do something even better because all the connections are being made in real time, and you're getting the reaction of the audience. It's like the difference between Rodney Dangerfield going and, what was the gopher, Caddyshack.
Caddyshack, yeah.
Like, I heard that when he was doing Caddyshack, he thought he was bombing, right? Because he's looking around and nobody's laughing, like, oh, tough room, like he's just not, he's not happy with it because he's used to being a comedian and reading what the jury's doing, right? And that's not to say that jurors, are active listeners. Sometimes active listeners are just nodding their heads and they don't agree with you, right? So you've got to understand what they're communicating to you unintentionally. Like, what are they writing down? I remember one trial that I had, I think it was up in Lynn County. We had jurors crying. Like, 2 jurors started crying during my closing. And, that was the best feedback I've ever received in a trial, and I'll probably never get that lucky again. I mean, it really resonated. Like, the story, the truth resonated so much. And I didn't write that beforehand. I was just telling the truth. I was just speaking from my heart. And I wouldn't be able to speak from my heart if I hadn't prepped over and over again and know the facts inside and out, because I'm pulling it from, like a computer algorithm, like a computer program. You can keep stuff in the cache that's always right there, or it can be back somewhere in the files and it takes a little more time for the computer to go grab it. Like, we need to have everything easily accessible. It needs to be on the bookshelf, not in the warehouse. So how do you do that? How can you even afford to do that as a lawyer? Because you can't sit around and memorize a case all day or the client runs out of money.
That's a good question. We do that by minimizing how many clients we take on so that each person gets all that front-loaded energy and our commitments to their case. So we're very selective. I think like the Marines say, the few, the proud. We select cases that we believe in, that we feel we'd have a great relationship with the client, that would be of interest, and we also want to defend people who are being taken advantage of or being accused of things. So we talk about cheap law versus expensive law, and a lot of lawyers have poor systems in place where it's volume for income, and they don't have time to hear cases. I get repeated clients telling me, my attorney showed up with me to court, but he's just barely looking at the file and he asked for more time because he didn't know what was going on. We know what's going on because to someone else's 100 cases, we selected 20 because that's where we can still dedicate maximum time to our clients without sacrificing their case at all.
I think you hit something I haven't really thought much about. Like, why do we always have instant recall of the facts? We know, like, all these clients we have, we know intimate details off the top of our head. I think it's really because we are super interested in what their story is and what happened, and we really, really are excited to help them. So we just get into it, and then because it's so important to us, I think it records as memory better than cases you don't care about. So it's easier to recall data that would be useful. Like, maybe you don't even know it's an important data point, something the client told you in an emotional meeting that maybe at the time just seemed like surplus, right? They're just telling you something that, that's bothering them, but isn't really a fact in the case. But then later something else connects it. Like, our clients always bringing up all the wrongs that have done to them that are clearly inadmissible evidence. They don't know about improper character evidence or relevance. They're just telling you what resonates to them. And I think a complaint I hear a lot from clients is, oh, my other lawyer or other guy I talked to, he said, oh, I don't want to hear about that. Yeah, he's not because he doesn't care. It's because he's trying to be judicious with his time and redirect you to something that matters to win the case. And you can let clients go on, and you can kind of lose control, and you don't ever get to the heart of what they need, and that would be wasteful. But at the same time, if it's important to them, and maybe later it becomes important to the case, maybe it's a motive to fabricate, or it turns out to be a witness later that you connect up with the case. So I think just the most important thing for a case is to know the client and to know their story, because we're hired to tell their story, to be their advocate, to take all these random chaotic facts that resonates with them, that they really care about, and they think will win their case. Because they're telling you this stuff because they want to convince you to take your case, because they're selling to you too. They want you to care. Because they know the more someone cares, the more attention they get, and the more attention they get, the more likely something novel will happen, or the attorney will be prepared.
Yeah, and that's the important part of the initial consultation process, onboarding is, and it's something I take pride in for me personally, based on my degrees and the different work I've had, masters in mental health counseling, I've done law enforcement, municipal court judge. I deal with hundreds and hundreds of people. I did public defense work, so volume work. I learned people, I understand them, I could read people pretty quickly, and what I learn is if the person sitting across from me feels that I understand them as a person, then they trust me with their problem. The problem doesn't matter anymore. I trust Frank.
Yeah, it's trust.
Taking my case on. He gets me as a person. Sometimes I make people cry because they haven't even said it, but I know there's something going on, and I say what I feel, and I say, tell me if I'm wrong, but this is what I'm interpreting and the things you're not telling me, but I'm painting a picture, and tell me if this picture's wrong. And I'll get some tears or thumbs up, like, wow, how'd you know that? So that relationship's important. In addition, when you talked about, we have a passion, so that's why we can recall these facts, because we know that the facts are important in the case and information. Part of that is we work in teams here, and we're revisiting cases weekly. And we're constantly communicating with clients through our portals, through phone calls, emails.
Feedback loop. Yeah.
Yes, so it's never something dead that I have to go dust off a file. It's active every week or so. It's fresh in my memory. I'm reviewing what we just did, and then now what are we gonna do, and looping the client in. Clients never just, hey, let me handle it. You go stay over there and pay the bill. No, you're part of this. You're gonna get everything we get. You're gonna get everything we send out, and you're always going to know what your attorneys are doing. You're not going to be in the blind like, I don't even know what they're doing on my case.
Yeah.
From the detailed billing statements to our constant communication through our legal assistants, paralegals, and the attorneys, this is fresh in our heads. It's just part of the passion of what we do.
Yeah, because if you link in what people are wanting at the beginning of a case, when they first contact a lawyer, they want understanding, they want to be able to trust you, they want to know that you have a way to win their case. They're always asking in their own heads or when they're researching, it's all from a motive of how do I win my case? What do I need to do to get what is due to me, what is just, what is fair? How do I win, right? And they want to trust that the person they're talking to understands them. That's important. But you can understand someone and tell their story back to them and not have the tools and skills to win. Like I may be able to say, okay, you can do this play in a rugby match, and you could go on the blind side or something, but I'm a mediocre athlete and I couldn't do that against a Kiwi in a test match or something, right? I wouldn't be able to do it because I don't have the skills. I mean, I understand it. I know what needs to be done, but you can't execute. And I think we have to have all those things to have a winning lawyer or a winning strategy, right? Because I think clients are coming to us and they are looking for empathy. And empathy almost gets a bad rap nowadays with suicidal empathy and how you can project your weaknesses on someone else and try to have the savior complex. And you see a lot of lawyers do it. They can kind of get to the dark side where they've got like a borderline personality disorder client, and all of a sudden they've taken on the persona and are projecting their lies out into the world, hopefully unknowing, right? Hopefully they believe them. Hopefully they've been conned. Sad.
Yeah, transference.
It's really an incompetence to be conned by someone that's not a sophisticated liar, because most people aren't sophisticated liars. Most people suck at it. But the other side of the coin, I think, is of what we do is strategic empathy, because we're listening and understanding because we're human and we care, but also we're picking out the pieces and translating their chaotic words into a narrative that would resonate with the ultimate fact finder. Because we're hearing, oh, what you're saying there sounds like maybe a weakness on the surface. Oh, I reacted inappropriately because, I flashed back to, this combat or this time I was beaten by someone else. All right, well, now we're talking about a reasonable person in your circumstance that has, your background would have reacted to, the car rolling up on you quicker in that ice situation that happened a little ways back where the gentleman had been hit by a vehicle in another stop. Okay, well, that's going to trigger something. So I've got to stand in their shoes and evaluate what they're saying, even if it sounds on the surface like super crazy and unreasonable. Because our job is to tell the jury why that initial cursory glance that the district attorney or the police officer saw as unreasonable is actually reasonable if you know everything and you understand. So they want to be understood.
And that's part of something you were talking about earlier that's still important, where they say their attorneys previously didn't want to hear anything. Obviously, client control is important to manage their money and our time. But in all the chaos and stress and the things they want to tell us, sometimes we find golden nuggets that trigger new strategies and responses and help frame a backstory that's information that they didn't give us originally. And it can be very useful. They're a very useful part of the team. And even if they give us 100 things that are useless, that 101 thing might be so useful and create a novel idea that we go and run with, and maybe what gets us that winning touchdown.
Oh yeah, like to be a gardener or a farmer, you have to have a little bit of mean in you, or a lot of mean. I always depressed me to plant all this corn in Oregon, because it's so much of it's going to rot because of our the rain early in the summer, late spring. Like Mother's Day, couple days later, you get a rain and it rots some of the corn. But next thing you know, you've got corn every centimeter going along the entire row. Well, now you gotta sacrifice a bunch of corn. It feels so crappy to throw it away, but you know your yield's going to be higher. Well, if you didn't cast all those seeds and risk some of them rotting, you would never be able to cull the best ideas. And clients, and even us, we come up with bad ideas all the time. And I think it's good because you're sowing bad ideas, and from there, maybe it turns out that bad idea just goes back into the soil as manure and fertilizes for the next idea that spawns from it. You've got to have high volume ideas. The only way you get that is if you know everything and you think about it and you talk about it and you bring it back up again after you get new information and keep going through that system of idea generation. Like, this is more of a tactic generation, right?
Yeah. And it's important. Clients, essential part of the team. They get anxieties. They come to us with ideas that might not be useful, but I think what sets us apart is that we will explain why that's not a good idea, and we'll explain what we'll do instead, or what we're filing, what we're researching, what a pocket memo is, and why we're doing certain things, so that they know our gotchas and ahas and preparation, and that we're ready to accomplish the end goal. Because sometimes clients just have these ideas, or other people are talking to them, giving them legal advice because they heard something or saw something, or what about this?
And you also got to keep in mind there's bad judges too. So a client will say something that, oh, what about this, and this? I go, that's inadmissible. Like, clearly inadmissible. Like, no chance. That is improper character evidence. It's irrelevant. It means nothing. Next thing you know, in a bench trial, you object, improper character evidence, overruled. And all of a sudden, you've got this entire side story in a case that you're not prepared for. If it's a civil case, you maybe didn't do depositions on because you deemed those witnesses irrelevant. But because a judge made a bad decision, now you're caught off guard. Now, you can't prepare for everything. That would be, you don't have unlimited funds. But if it is something attractive that the other side would want to do to defame your client and make them look bad, well, maybe you should have a couple-page pocket memo. So, objection, overruled. Well, Your Honor, can you reconsider? I briefed this.
And a well-respected local judge did a lunch CLE for the local bar, and I attended that, and he was talking about exhibits and trials, and he says in his last, I think he's been on the bench maybe 15 years or so, he's seen maybe 2 pocket memos. And it was surprising to me. I also went to another CLE with a lunch CLE with the family law judge and a couple attorneys that are well respected in town, and I was surprised at how unprepared they were for cases and collecting their evidence and documents and organizing them, being ready.
Yeah, so what's the cause of that? So, like, there's a couple causes to attorneys being ill-prepared. One, and the most understanding of all, it wasn't in the budget for the client.
Yes.
So the option is you go to trial pro se on your own, or you have me at your side without having invested a lot of time and money into requests for production and depositions, and that's probably better than going alone, unless it's a bad lawyer that's going to cause more harm than good.
Yes.
Right? And then you have people with bad systems. They are good lawyers with bad systems. Because they're good lawyers, they're unintentionally not tending to a case because other fires came up that they didn't prepare for because they didn't have a task management system, a project management system. Like when I talk to clients that have like software engineering experience or project management experience for construction, like they understand systems, and they would be just terrified to walk into a law firm of the chaos of how they calendar things to do, jobs to be done, tasks, to-dos. That's an important thing that's overlooked. But how do you even vet for that as a client? Like, how do you go into a law firm and be like, do you have the proper systems in place to make sure that all the work that needs to be done is prioritized and the choices are made and it's budgeted correctly and we're maximizing efficiency? Like, I think the proof is in the pudding. I guess you look at reviews and you listen to them, but how easy would it be to shine on a client that you're really good at your job and then it just falls into the pit of not being worked on? Not that the work that is done is competent, but not enough work has been done. I think that's that's the rub. How do you
Yeah,
know?
yeah, and that, I think that sets us apart. You know, a lot of attorneys have checklists for a type of case because that's all they do, and we take on a lot more complicated cases that no one wants. They don't want them because it's too hard for them. They don't have systems. They don't have the experience and knowledge, and we have redundancy built in. Our systems are tasks and micro tasks and subtasks, deadlines, priority levels, checks and balances. Someone's going to review what I did. Someone's accountable to tell me, how come you haven't looked at that yet? I'm accountable to someone to say, have you reviewed that? I gave you a date and time. So we have very complex, detailed systems that cover everything from A to Z that you can imagine in the case. And we're constantly refining it as new novel things come up. That's part of our checklist. We can check it off that we're not going to do it, but we reviewed it. And that's part of, our due diligence.
Yeah,
for
yeah.
our
The
clients.
ruling out phase where you've got
Yes.
your master task list of everything that could possibly be done in this case. Maybe it's 300 tasks long. That if you did every one of them, it would be a $5 million case.
Yeah.
Right. And maybe there's somebody that wants to pay $500,000 for a simple bar fight and turn over every possible rock and chase down every possible witness and set up surveillance at the bar to see if you can track down the guy that you kind of saw on a security camera that may be a good witness. Like there's ways to get to the truth, to like time travel back to the situation. And most of those are like 1 in 100 shots. So eventually you have to trust your common sense and experience and say, no, we're not going to do that. So you rule off all these things, rule them out. And then in the process of ruling things out, maybe it triggers another idea in your head that you write down as another possible task, right? So you set it out, you revisit it later once you do a little more work. Those processes are expensive because you're touching the case a lot. But what we've discovered over time, by front loading that work, cases increase the likelihood of settlement quite a bit because you're not convincing the jury that you're right. You're convincing the other attorney that you're right. And then they're convincing their client or convincing their victim, or because of the motion hearings and the discovery, you've convinced the other party that the jig is up. I'm going to be proven to be a liar. And next thing you know, in discovery, we get a letter that was sent to the DA saying that they don't want to go to trial because they're scared of the other lawyer. And by the way, they drank too much and don't remember what happened because they've given themselves a golden bridge to retreat upon that. Oh, I don't remember anything that happened, which is code. Oh, maybe they're afraid of a perjury charge, which would never happen because they don't prosecute false accusers in Oregon, at least. So there's some benefits to be paid. It's like, okay, I can spend X dollars to try your case. That's what it costs. Or I could spend X dollars to prep your case, and the odds of not trying your case increase a lot. And therefore, the risk profile decreases. So you upload the work, and if it doesn't settle, it's way more expensive to try it, but you're that much more prepared. So that's the rub. And what if you overspent and you lost anyway? Well, I don't know, because that doesn't happen. It's going to happen one of these days.
Yeah.
Going to have some losses on because we misevaluated or got a bad luck with the jury or something happened. But in that process, clients, like for instance, clients that plead guilty to something, when they spent as much as if they went to trial and got the same result, they go to prison knowing they didn't leave anything on the table, or they go to a custody trial knowing that, hey, I may have lost custody, but it wasn't because of a lawyer incompetence or because they didn't do all the work. It was way more expensive than any other way to do it, but at least everything got done and I didn't leave anything on the table. So it's a matter of stakes. Like, what's it worth to spend a lot of money versus like maybe a client just needs a free consult. Like I was talking to a client the other day, a potential client, let's say, and I call him on the way home every once in a while to check in on him. And, he's saying, oh, the lawyer's not doing this, lawyer's not doing that. So I give him some tips on how to communicate to his lawyer to encourage him to do something. Yeah. And he just starts crying on the phone saying he can't even imagine another lawyer spending as much time with him as I have. Well, I guess every attorney's got a sliding scale, right? Because attorneys all the time are giving away free legal advice because, oh, this guy's just on the wrong direction. He can't afford the lawyer he's calling. but that lawyer has a couple minutes to at least give them, give them some ideas that maybe that saves the day. And a lot of lawyers do that, and so a lot of them do it unintentionally, like involuntary pro bono. They get into a case and they don't have the systems for managing the expenses and the revenue, but there's always more work that can be done. Like we have a shortage of attorneys. We need more clinics. We need more videos online of attorneys basically telling the secrets on how to win a case. The secrets. I mean, it's no secret. You just put in the work. There just needs to be more content that isn't goofy attorneys. It's so ubiquitous to hear, what do you do if a cop pulls you over? It's like, okay, that bit's done. How about, what do I do if I was served with a notice for hearing as an abuse victim, and it's got expedited consideration because there's kids involved and I got to go to trial next Monday because I didn't check my mail, and all of a sudden it's Thursday and I'm spending the day looking for lawyers. Nobody returns my calls and I'm spending all weekend trying to get ready. I want to watch like content of what happens at a hearing. Like what's the odds of, or how do I get a postponement in order to get a lawyer? What's the magic words? How do I get this evidence introduced? Because I mean, how many times are we talking to people and they're saying, oh, I'm going to bring in this written statement. It's like, no, that's hearsay. But my friend isn't available. Oh, that's a subpoena. Like they can be done without a lawyer. It's like the law is protected, like some Gnostic priest class that only the elite get to know, when, we give this stuff away for free all the time. Here's how you win the case. Yeah. Can you do it?
And that's part of why I feel we're special, is we believe in people. We dislike liars. We're truth seekers. And as you talk to people after hours, I squeeze people into my busy day and give away free advice. They might not be able to afford this, but it's not generic. And we want to help people. I think that's why we entered this profession, is to help people. We believe in the law, and we take some extra time. That's why I have longer days and weekends, because I'm squeezing people in to try to give them some hope and give them information and knowledge. Even if I can't be the one that helps them, I'm helping them in that moment, because they can go to sleep tonight and they heard from an attorney, not an answering service, or we'll get back to you. And they talked to a human, and I humanized it. I validated their concerns. I gave them some information to go with, and maybe direction of where to look. And give them some comfort.
I haven't thought about that, but we do that a lot. Like
A lot.
We jump on the phone and say, hey, you don't have time to take your case, but this is a big emergency. Here's some ideas. Don't panic. It can be taken care of next week. Here's some things you can do right now. And I think that comes back to systems and processes too. It's not just, hey, I feel like talking to this person to help them out. Like, how did that person even get me on the phone? Well, it's because you can blame, Michelle at our office.
Yes.
She's banging on the door, trying to interrupt us, saying, hey, this person's got, policeman at his door, or his kids are taken away, or this thing got posted online. He's looking for a lawyer. No, he's not looking for a lawyer. He's just looking for some answers. He may think that the lawyer's the answer, but maybe it's another answer, like, oh, don't do anything. You can wait. This isn't a crisis for these reasons. Here's some self-help. And you just saved him $10,000, $15,000. Or maybe it needs to be done by a lawyer and they don't have the money to do it, and we can refer them to somebody that may be more affordable, or to a video that describes how to solve that problem. I'd like to see more lawyers putting out like video content on their strategies and what they see often, and how the process looks from their perspective, different counties. Like, I think lawyers in every county, you should be able to Google Josephine County, Oregon restraining order hearing, and there should be a lawyer saying, okay, this is how this courthouse does it. You go to court on such and such day of the week, or such and such time. You apply, the judge calls you, because every court does it differently, but it's like a mystery.
It is.
We got it. Lawyers. That's why it looks almost like Gnostic priesthood, because lawyers have value because they decipher the mysteries, and that's because of a system that's created to give people fair process, due process, but there's not a system of making process literacy. So the process exists, the words exist, the book is here, all the answers are there, but you don't know how to read. Or you maybe know how to read, but you don't have time to read a treatise on evidence before Monday.
Exactly.
And I think that's another reason that ChatGPT and Grok and all those AI programs that people are using are getting a bad rap in law right now. Lawyers are using hallucinated cases. They're not site checking. And again, that's a systems problem. They didn't have the time to do it because they didn't have a proper system in place. And judges are complaining a lot that people are coming into trial reading these AI generated slop scripts that mischaracterize the law. And that's because this tool is being misused. Somebody is using a hammer instead of a shovel, and maybe it makes a dent in the ground, something that resembles a hole, but the dirt's still there. It's just hard and more compact. And I think we need to maybe train pro se litigants on how to leverage ChatGPT, like how to describe your problem and ask some questions like, all right, this is what happened. Is this relevant in a Oregon restraining order case? And then have a conversation, a brainstorming session. It's always got to be, you can't trust it unless a lawyer signs on. But man, they got nothing else. I mean, they're turning to whatever they can find for help. So why aren't we teaching pro se litigants on how to leverage AI to prep for trial?
Exactly. And, most people in junior high had to write book reports and use the encyclopedia or something and cite their sources. So same thing with chat. Chat's helping you as a tool confirm your sources, But people are in a panic. The law seems above their head. They don't understand there's uniform trial court rules. There's supplemental local rules to each court, like you're saying, Jackson County. And then there's unwritten rules.
Customs.
For the judge, for that courthouse, for the presiding judge, that people don't know and understand. And as a pro se litigant, you're acting as your own attorney, so you're presumed to understand the evidence code and the rules and what you have to do. And, as a municipal court judge, people come in for their hearings all the time with a bunch of letters. I'm like, you need to look up the hearsay rule. I can't accept that letter. That's an out-of-court statement.
Yeah, so you could imagine, like maybe we should create a GPT that has all the local court rules. Like you can do it for a practice area. So say you wanted to create a pro se tool for restraining order cases. How would you go about creating that? Well, the best possible situation for a pro se person is to have a lawyer sitting behind them, feeding them stuff. Okay, might as well have them retain them for trial. So that's not cost effective. Okay, the second best thing is to have a lawyer you get to go ask questions to and schedule like little one-offs. Okay, what about this witness? What about this? How do I do that? Like pro se coaching. All right, well, what if I can't even afford that or there's no time? Okay, I'd like to be able to ask an AI program and have at least spit out something. Like what are the options in a case like this? Or is this relevant? And I remember we were talking the other day with a Westlaw representative, Westlaw being the lawyer's search engine for case law. And we were getting ready to sample their AI search software.
Yeah.
And he's like, well, give me an example. I was like, all right, well, let me just turn on ChatGPT. ChatGPT, give me a Westlaw prompt for the new AI feature that looks up, anti-SLAPP litigation and is X, Y, and Z, relevant and how, like whatever the little random question was. And then it popped out this prompt with an explanation, and the comment was, oh, some of that's not public. Remember him saying that? He made a little comment like, how'd ChatGPT know that? They must have scrubbed something they don't have access to. And ChatGPT created a beautiful prompt for the AI system of Westlaw that you have to pay lots of money for.
Yes.
Because nothing's free in this world, right? So, yeah, you can leverage ChatGPT for research. Okay, maybe I'm preparing for a client or a meeting with an attorney and I want to get my money's worth. Maybe I should run through with ChatGPT some ideas about what I should ask the attorney and be better prepared.
Yes.
And then the one thing I guess is a cautionary issue is in a civil case, will the opposing attorney subpoena your ChatGPT records since they're not privileged because you're not talking to a lawyer? How do you make that anonymous? Well, you can't if you actually requested the records. I'm going to have to research what's going on with that because they are you can't subpoena them. You see them in the wrongful death cases, right? The suicide cases, the overdose cases.
Yeah,
they're getting access to the records.
That's recent stuff in the news and media. Yeah.
Yeah. So
yeah, the law has to keep up with technology.
I mean, because I can almost imagine a modification of the rules of evidence for a patient therapist sort of privilege, an attorney-client privilege for using AI to prepare for the case that's being litigated, because that's just not fair. Like, you shouldn't be able to get into my strategic mind when I'm using the available tools as a pro se litigant to fight a lawyer, and they can turn around and subpoena those records. But then again, if you make it, you have to have an exception to the rule, because you don't want someone to go use that as a cover and make a bomb and then not be able to subpoena their records to prove that they made the bomb. Expert witness in a potential bomb making case. Like what are the cross-examination questions on how to turn this fertilizer into an explosive device? Tricking the AI to answer that question. Like, you want that still to be subpoenaed for law enforcement.
Yeah.
So I wonder if that's something that lawyers should be having a conversation about, is how to amend the rules of evidence to allow pro se litigants not to be brain raped by the other side.
Yeah, I'm just thinking out loud. If you're pro se, you're acting as your own counsel. I'm wondering if some sort of preface in your chat which says, I'm acting as my own attorney. This is confidential work product before you. And here's what I want to know. Wonder if that would block that. I know it's just, as we're talking, this is how we operate. We find something and then it's novel and we go do some research.
Okay. So I'm going to tell my potential clients right now, if you're prepping for a potential meeting with me, feel free to use ChatGPT only if you preface it with, my attorney requested me to leverage ChatGPT to prepare for this meeting. Because that's more defendable.
Yeah.
Because now it's like the inmate that's making notes on a piece of paper. Is he writing a bomb threat? Is he doing something that he's not allowed to do? No, he's saying, dear attorney. Like, that's what we always tell them to do. Make sure it's a journal for your personal injury case. It's for the lawyer.
Legal mail.
It's for work product being prepared by me at the request of my lawyer, rather than me making a journal that's somehow discoverable. So I think that's the trick. It sounds more like a journal and discoverable, and less like work product that my attorney asked me to do. So I'm asking you to do it.
Yeah.
Right.
That makes sense. Yeah. That's more defensible.
Something to think about. I think that's maybe the short-term plan, because eventually attorneys are going to realize that bad actors are spilling the beans to ChatGPT a lot. Like, I want to know the prompt of a liar, right? Because I want to hear their inconsistent statements that ChatGPT has that I can now use against them, because they shouldn't be allowed to leverage AI to lie and I not get my hands on their inconsistent statements. But at the same time, maybe we're willing to sacrifice this extra bit of discovery for the benefit of everyone having access to these tools. And then you got to worry about the privacy concerns and how the oligarchs are going to know our most intimate knowledge. I mean, it's a scary world out there, but if I have to balance between fighting for my kids being taken away or going to prison or having my reputation tarnished, and a possibility that one day, the oligarchs are going to use this against me and the government's going to come knocking at my door. I mean, real dystopian future versus right now, family life, survival being at stake.
Yeah.
It's a complicated world.
It is. And this technology is changing every day. Just going through my own social media, it's always shown me a new AI program. Probably seen 8 or 10 different ones. Some focus on attorneys, some focus on pro se people, and some just claiming to be better than ChatGPT. And others saying there's 20 different AI apps that you can use or technologies. Take our course so you can use each one to this maximum.
Yeah, it's AI literacy.
It's AI literacy, yeah.
Yeah.
And it's just, I think we're seeing the boom with, technology. They say like changes every 6 months, but I think with this artificial intelligence, it's moving really quickly.
No, and that's a tool that can be used for great good for pro se litigants, and they should, and for lawyers, because I've seen some lawyers that I really respect and I refer cases to and I think are awesome that make a public vow never to use AI.
Yeah.
Because they're seeing all the worst case scenarios online, because online you hear about the hallucinations, the court sanctions, the ethical problems. But you don't hear the stories about how somebody came up with their great closing argument theme from brainstorming with AI and walking through all these different iterations and coming up with the best possible narrative, hook intro to their jury instruction or to their jury questions and voir dire. You don't hear those stories, and you don't hear the stories about how, oh, I was able to access this piece of information really quickly because I got client permission to create a GPT with their information in the knowledge base and then accessed it very quickly. Like, where in discovery is this? So eventually, all attorneys are going to be able to go to their platform, whatever it is, and say, all right, I was thinking about this case last night, and where in discovery is this point? Oh, I don't find it in discovery. Okay, well, is there something kind of like that in discovery? Yes, on page 5,000 of document NN252, there's a reference to that. Okay, that's where I remember that from. Like, it's not asking AI to go do the work. I mean, you can do that too. Like, there's programs out there that will look at, for personal injury matter, will make sense of voluminous discovery, medical records. And so the future will be that. It'll be like the most brilliant legal assistant or most brilliant attorney that knows all the facts, has it at its attention, that's in your pocket. And you can ask real plain language questions to get access to the discovery in the middle of cross-examination.
Yes.
Like, this is all, like, what is cross-examination but just a slow death by 1,000 scalpel cuts or a rapid machine gun execution over and over again, where you're just knocking off, pieces of their flesh until there's just down to the bone. Rapid fire. And you can't have rapid fire unless you've absorbed into your DNA all the relevant facts that you can turn around and manifest at a moment's notice as the witness pivots from one issue to another.
And the key word that you used is a tool. It needs to be instructive to you. You need to know how to use it. And even if an attorney's using it, their skill in presenting this knowledge in an orderly fashion and precision, and in creating narrative and getting the end result in front of judges and juries and opposing counsel, the people that we're up against, and persuading them and telling stories. So this is an excellent tool, but that's what it is, a tool. It's not going to replace our mind in how we present things. I mean, that's an important part for us. Excellent tool, if used properly, to help us refine how we create our system for trial, for fighting, for negotiating, for showing the other side, we're going to win, you're wrong. Why you should back down now and offer you that golden bridge which to retreat upon. Give people an out. Don't back them in a corner. Show them why they're wrong and show them a graceful way to save face and exit.
Yeah, and there's ways that people can do this themselves without lawyers too, right? They can be educated by a lawyer in a one-on-one conversation, to prep for trial, and the lawyer can ask you questions at trial, and the process works if you have the bank account available to do it.
Yeah.
Or a lawyer can tell you what to do in a one-on-one, or a lawyer can teach you in a webinar or with free material online. And what I'd like to see more of is teaching people in the public on how to do it themselves, how to research these things, how to learn and be better prepared. And then I get, complaints. Well, if you put it out there for free, then, the liars will get a hold of this and they'll be able to con the judges easier. That is true, right? They'll be better prepared. But I would be happy if we had a criminal justice system where everybody used 100% maximum efficiency of the rules of evidence and told every relevant piece of information in a coherent way for the judge and give the judge the best chance to make a decision. Yes, you hire lawyers to get an advantage, but I just think rising tide lifts all ships. And if we're giving it away to the pro se people doing restraining order hearings on how to win their case, even if the liar's in there falsely accusing someone, or even if the abuser's in there and going to leverage, his manipulation skills, that's fine, because the crucible of cross-examination, if you can teach someone how to do it in a coherent way, that makes it easier to expose the other side. And they're not, and you see all the mistakes of pro se litigants asking the wrong questions and getting sustained, or the judge getting mad at them, and that can be prevented.
It's hoarding the law. It's out there for anybody. I can change my oil. I can change my tire. I can fix my car. And at times I couldn't afford to pay someone to do it, and I did it. But today I'm going to pay the expert to do it and not do it. So I don't feel threatened by what you're saying. I think that people do need the help, and they're doing it anyway. The ones who can't afford it, lawyers still go. It's better to provide that. Everyone needs a fair day in court, and some people have an advantage over others. Some people are better actors, narcissists, and can manipulate systems and judges. And what your idea is great. Lawyers are still going to be needed. People are still going to hire lawyers because even if you could do it yourself, it's not my skill. I'm gonna pay someone to do it because this is what they do professionally.
Yeah, but lawyers need to be better teachers, because if there's most people cannot afford a lawyer to go with the most common cases. The most common cases being family law, like custody cases,
Yes.
where you can alter a child's life forever, or a restraining order case or a stalking order case where you can alter a child's life forever. Like maybe dad's not around ever again. Maybe mom's not around. Maybe, the kids aren't involved, but earning capacity of dad is destroyed by these false accusations, and thus can't get access to, his work because of a stalking order. Like these things really matter, and lawyers need to be better teachers. And it's, like lawyers have been trained, and just like hunters have been trained, just like fishermen have been trained. You can be a jack of all trades and maybe a master of a couple, but just like you can, change your own tires, do your own oil, it's good in a survival context, but as you get older, you don't use those tools as much. Just like we don't use our tools as much in the, doing family law and restraining order cases, because there's higher stakes demanding our services.
Yes.
And so we're not able to help those people, but we could help them if we gave away like the secret sauce for free. And and us being, despite good communicators, we abhor videos. We don't like being on camera, and most lawyers don't. So I'd like to encourage lawyers out there to give it away for free. Use that. It's marketing collateral anyway. Like someone's going to hear that you're an expert and like the way you communicate and trust you. Great. That means now the market is cleaner. The market is more efficient, because you go to an attorney website. The attorney websites, they all look the same to me. Oh, a bunch of people in suits. And I know that, their little biography talks about, they got a dog, a kid, and they like to go on hikes and moonlit walks, and they have this past experience, and they have, this track record. Okay. Oh, now we see some representative cases. I'm getting more detail. Now I'm learning more about them. Oh, I can click on this link and I can watch them in court because it was televised on 48 hours. Oh, now I know more about them.
Yeah.
And then I can call them on the phone. And I can learn about them. Or I can watch hours of videos and learn everything there is to know about my case. So I'm that much more prepared no matter what lawyer I hire. And then I ended up hiring you. And boy, my attorney fees are a lot cheaper because I'm inside the attorney's head already. I know what they're looking for. I know how to communicate to them. There's just so much value to lawyers getting on camera and just shooting the shit, just talking about what they do, because it shouldn't be a mystery. And if someone else learns from you, and you've mentored them accidentally and they become a better lawyer and kick your ass in court, great. That means the system's working and everybody has equal access to the law because they're maximizing the evidence code to its most efficient levels, and society is better because truth is more likely to prevail.
And we talk reality here. I do enjoy the law dramas on TV, but never is it completely accurate. And a lot of people watch these types of shows and misunderstand how the system really works. So educating them, it even makes them better clients because they're in the loop, and even if they're not doing it, they know the work we're doing. Going back to what you're saying, we can't help everyone. We give people access by sharing knowledge. I'm amazed by how many people who want to leave us reviews that didn't even hire us, couldn't hire us, just talk to us, and we gave them information that they're happy to even talk to an attorney. They've called 20 attorneys and no one's returned their calls.
I got Michelle sitting outside my office doing, talking to potential clients all day long.
Yeah.
And I hear what she says to them. She's not asking them to give her a review or something. And then all of a sudden pops up, oh, Michelle was so helpful. She gave me so much information. And what I know what happened is she listened to them. She said, okay, the type of lawyer you need is this. Our lawyers, they could help you, but you need this budget. why don't you call this lawyer? And they just gave her, maybe she just gave a referral.
Yeah.
Or maybe she just went and asked us a quick question. Hey, this person seems that, got this problem. Oh, why don't you tell them to do this, this, and this? And they'll be on the right track, and, and they can buy themselves some time. That's just, I always say that even a sociopath can be, good at business, can be a fair businessman, because just helping people, it pencils out. Like, of course you want to hire someone that's helpful. Like, it's just contagious. You shine the light, and it doesn't divide the light when you share the flame of a candle with someone else, right? It just lights their candle, and then they can go illuminate the truth. Or maybe it's a family member that's calling why the client's in jail and seemingly unimpressed by their public defender.
Yeah.
And we jump on the call and say, oh, no, actually, that's a good idea. Give them a quick second opinion. That's a good idea for these reasons. That your lawyer probably didn't have time to talk to you because he's overworked and underpaid, but most likely that would be the answer. You just give them some free legal advice. Why don't you ask them these questions? Why don't you write a letter down, and say, hey, what about this, this, and this? And at least get the process going. There's ways to help people better communicate with their lawyers too. So maybe the other side of an audience for lawyer conversations is not people looking to hire a new lawyer. It's someone that's stuck with their lawyer, and they're disappointed, or they're concerned that their lawyer's not doing everything that they can. And if they go out and learn more about the law, they'll realize that their lawyer maybe just didn't communicate it correctly, but they're on the right track. Or they can see that something is being neglected, and they can, and that's tough. You don't want to piss off the lawyer, right? Like, you don't want the client to alienate themselves, right? Like, you got to teach them how to tactfully ask the questions without seeming bossy, or like, I Googled that, or ChatGPT told me this, because that's so irritating. Like, no, I'm the expert here. I know what's right. But sometimes there are, bottom tier lawyers that can do a better job if the client was more informed on his own by doing his own research.
Yes. They have questions that never got answered. They don't know what's going on. I mean, what's the biggest complaint to the bars?
Didn't return my calls, yeah.
My attorney doesn't call me back. I don't even know what's going on. I haven't heard from them in a long time. So that's key. The more informed the client is, the more they can relax knowing, they're in good hands and something's being done for them.
The most important system that an attorney can have for good client relations and good results is a efficient feedback loop between the attorney and the client and the attorney. The old adage that the number one bar complaint is the client didn't return my calls, didn't respond to my text message, didn't respond to my emails. Well, you don't need to get an MBA to learn how to run a business. You can go watch TV. You can go watch Silicon Valley to learn how to do a startup. You can go watch Mad Men to learn about how to divvy up creative from client relations. Because an attorney needs to be both Don Draper and Sterling or Duck or whatever, hopefully not Pete Campbell, but you've got to be able to communicate to the client and keep them happy and bring back the ideas and tend to them without wasting the highest billable hour person in hand-holding the client. But at the same time, that person has to understand the case. So when they are communicating with the client, they're able to direct them and get more information in a way that's most impactful for the creative team, for the people writing the narrative.
Yeah, correct. And that's why we meet as teams with our legal assistants and paralegals, investigators, and attorneys, because everyone's up to date. Almost any one of these people could respond to a client's question because we're all on the same page. We're working synergetically.
Yeah, and that's not cheap, right? So
it's not cheap.
So you got to figure out a way to be the most efficient with that. If everybody's got to read the same documents to be on the same page, it's got to have like the synergy that you described. 1 + 1 has to equal maybe 10. It's got to have some impact. It's got to be piece through strength. It's got to be a force multiplier. Like, what's more powerful? 10 guys coming at you one at a time to try to take you out, like in the movies, or you just flanking them in a circle and charging them all at once. I mean, that's how you take somebody out. You do a force multiplier, because 3-on-1 fight, one at a time, with an unprepared or unsophisticated fighter, I probably have the stamina to handle that, assuming that they're not, a skilled fighter and just some random, losers on the street causing problems that aren't usually well trained and disciplined. And you can learn that by their behavior and how they move, how they stand, the width of their feet. But 3 of them attack you all at once, and they got another force multiplier. They got a weapon. Okay, well, that's a different story. So what we want to do is we want to weaponize everybody at the law firm to provide maximum impact. Maybe this person here needs to be communicating with the client more, because the client's got a lot to say, because this is a 4-year episode of their life. And it's just not possible for the attorney to hear it all at once. You need to have that other person take it all, write it out in narrative form, and then when you meet with the client, you can refine it and repackage it and learn and ask them questions, and then increase the database that is the facts, the ordered facts that go into the final series of symbols and words and witnesses that resonate with the jury.
And that's part of our system, right? We all have a certain role. And when I say we meet as a team, everyone has a different role. Like you say, investigator might talk to the client. We're trying to maximize resources, attorney time, client money. Investigators going to take that information and synthesize it into something manageable for the attorney to review. And then the attorney is going to review it and then be able to come back with something. So instead of an attorney spending 4 hours talking to you, getting that information, then needing to memorialize it and turn it into some sort of usable memo document we keep internally for everyone to be able to reference and have internal and systemic knowledge.
I think lawyers, the law practice, a real important metaphor is the medical system. And you mentioned that to me this morning. We were just having an offhand conversation. And I think that is a very valuable metaphor. So you've got the concierge medical providers, the doctors of the elite, the oligarchs, the celebrities, where they pay $200,000 a year, where they get instant access to the lawyer or the doctor that has the cutting edge information about whatever's coming up through the university systems. What's the next novel molecule or supplement or treatment? What's separating the wheat from the chaff? Because I can't become an expert on what's the most likely cancer novelty treatment right now. Like I want to before I make a decision, but I want to be able to trust someone else to filter that information for me. I want to have concierge medicine. Well, ChatGPT stepped on in. It's reading people's, Grok's reading people's medical records and giving them diagnoses and pointing out things. Great. That's a great tool. But still, I'd rather have the smartest guy in the world that I pay the highest premium for. Just like I'd like to have the best lawyer who's going to be the best storyteller, that has the best memory, that understands me, that gives me one-on-one attention, that's always by my side. Well, that's not possible for most people. Only the elite get to have access to an attorney, like a Tom Fagan, or was it Tom Hagen from Godfather, right? The Godfather has one person that he turns to. He's got a special practice where he just has one client, is what he tells the producer in Hollywood, right? And we all want that. ChatGPT has become that for a lot of clients and a lot of attorneys too. It's been their somebody they can ask questions to and argue with and brainstorm. So there has to be different tiers. There has to be the consigliere. There's got to be the concierge medicine. Mm-hmm. There's got to be the lawyer that's the best lawyer on the planet that just takes one case at a time, and it's you. It gets his undivided attention and his entire army of competent attorneys behind him, because money is no object. Yeah. That has to exist. And there has to be Medicare, there has to be Medicaid, there has to be emergency room physicians, and hopefully there's a safety net that provides for that, so we can care for the weakest and most vulnerable. Okay, we have that with public defense. We have an imitation of that for restraining orders and stalking orders. There's clinics out there. Yeah. Most of the clinics only specialize in domestic violence victims and don't differentiate between domestic violence liars and authentic victims, where the victims are actually the one being falsely accused. So there is a hole in the system. There's still not enough people for domestic violence victims either. Like there's just not. Like,
No.
wouldn't it be a great system where everybody got a lawyer? Okay, well, we don't do that. We can't do that. It's not happening. It's the way of the world. And then there has to be other ways where the smartest guy on the smartest doctor has mentees under them that they're coming to him and or her and saying, all right, I got this real novel situation, and they do that, right? They talk it out. They talk to each other. Lawyers need to do more of that too. It needs to be more office shares where someone can walk down the hall and go ask us a more experienced lawyer a question and redirect that new lawyer. So there can be legal clinics out there where if all you can afford is this brand new lawyer, but he's at least got somebody down the hall he can ask questions to. It's like the Timu version of the trial lawyer. But you know what? A Timu tarp might keep the rain off you in a storm.
Yeah.
Might blow away in high winds, might rip apart, but at least it's there for the majority of the time, and it's better than nothing.
It is better than nothing. And the whole list you made goes back to why we're so selective. We're novel. We take the cases other people don't want. We look at cases differently than other people. A lot of people come to us because they're being told just to take a deal, and we after reviewing it, believe there's chances to win this, and we have ideas, and we put hope into people with our strategies and ideas that we want to execute.
And then maybe they go take the deal anyway because the risk wasn't worth it.
But they felt comfortable. We get reviews from people who get a plea deal, which was a misdemeanor that can be expungable in a few years, versus going to prison on these felonies. Mm-hmm. So even though it didn't go away, and they end up with a charge, they're happy and satisfied because we fought to the end and they were able to make an educated decision and choice for themselves based on the hard work we put in.
But still we're not doing it perfect, right? Because right now, if you get hundreds of calls a month and you've got to find a way to take a limited number of them to make a living and not be overwhelmed and not have risk to yourself professionally because you took on too many cases, right? Because you'd have unlimited demand for low-income cases, but you couldn't have a whole team supporting it, and you can't scale that. The only way to scale a law practice is the traditional pyramid scheme that is the practice of law with partners and associates. Mm-hmm. Now, the old system's broken where the associates are glorified slave labor designed to enrich the wealth of the person at the top. There has to be that downstream learning, right? Because you've got to be able to have somebody ask questions to. To go out there alone, which a lot of lawyers do because whatever circumstance, that's a tough way to practice law. So the best way is to learn from someone, just like, fighters, you're from such and such school. Mm-hmm. Oh yeah, Gracie founded this school. So you can trace your lineage to the Gracie family, or maybe it's 10th Planet Jiu-Jitsu. Maybe you're a boxer that was trained up by someone who's trained up by someone else. Maybe you're going on an ayahuasca retreat, and that person was trained by this person in this lineage of this indigenous ceremonial tradition. Okay, you know where they learned it from, and that's important. Okay, maybe you learned it from watching My Cousin Vinny. It's like, all right, you're the best cross-examiner of a hostile witness ever because you memorialized in your body the way Joe Pesci cross-examines his girlfriend in that movie, which is great. We actually watched that in law school, and also the cross-examination regarding the grits. What a great scene on cross-examining someone who you can't be too tough with. You don't want to be the asshole by being too hard, but you want him to answer the questions because he's holding something back because maybe he's embarrassed by his vision or the time or whatever it is. Like there's got to be that gut instinct on when to push the buttons and pull the levers and cross. How do you train that? Well, you can tell people it. You can do videos. You can have someone come watch a trial. It just takes time, and there needs to be less sole practitioners out there. There needs to be more lawyers that leave a legacy behind where they've taught someone underneath them. That, to me, that's the best legacy of an attorney is client satisfaction your own personal clients, but also the satisfaction of all the clients you never got to meet because they weren't your clients, but they got the benefit of your wisdom that you shared with someone else. I want to see
Makes
more
sense.
of that.
Yeah, I agree. Going back to something you said, about public defenders and all the different levels of types of attorneys, sole practitioners who have no mentors. There's a lot of good lawyers out there with too many cases and can't give you that concierge treatment that some people desire and need. What they offer is minimally competent constitutional defense. We don't want to be minimally competent here. We want to give top tier service. We like to execute a plan. We like to front load things. We like to attack early, quick, and gather data, come back and refine it and turn it into a plan that has contingencies. We talked privately before about being bored about a case because we know so much about it. We've attacked it from all levels and we feel ready. It's kind of boring now. Let's go to trial because we're ready to go.
Yeah, the problem with cases like that is you got that risk of forgetting the important things. You still got to go like re-prep a case for trial if a case gets postponed. There's so much expense added to preparation. You just don't have enough time in the day to manage everybody. But you make do with what you got, and you try to be efficient with your time. Another thing that I was thinking about is, what does the supply and demand curve look like for the practice of law? Well, I can learn a lot about the supply and demand curve by looking at, like, for instance, reviews of low-cost legal clinics. Because what I know is there is a high demand of people wanting free or low-cost legal services or pro se coaching, but there's a low supply of folks willing to give that service. Therefore, there is a hole in the market in the supply side of that equation. There needs to be more legal clinics that offer, or more people offering sliding scale services or pro bono services, which I prefer never to do pro bono, because my experience and the research is that people that get something for free act like it. And that's a huge risk, and I don't got time for ungrateful people.
Yes.
I remember when I was a brand new lawyer, an experienced lawyer was complaining about how he didn't have enough cases and he was just twiddling his thumbs. I was like, well, what did you do all week? He said, I watched a bunch of CLEs and just sat around and read the paper. I'm like, well, why didn't you just answer your phone and talk to some people and give away some free legal advice? I don't do that because those people are ungrateful. Okay, well, I learned something from that meeting. So I would put people on, take $250 for a retainer, and then the client would agree to pay $50 a month for the next however long. And I remember there was a time where we were getting blackberry cobblers and roast moose, and that's all they could pay.
Yeah.
And now people seem to reciprocate with different sorts of gifts or reviews online. It's a different world today. But what I'd like to see is more attorneys getting trial experience because they're devoting 5% of their time to taking on sliding scale cases where a client can only pay $250 for a restraining order hearing or a stalking order hearing. Well, why would a young lawyer want to do that? The same reason young lawyers want to go and volunteer and be prosecutors, so they can get trial experience. And also they can help someone in need. So there needs to be a better development. Like, for instance, you could take any law firm and you could say, this law firm is going to have a legal clinic attached to it. All right, what does that mean? Okay, maybe it's an assumed business name where you differentiate and when someone comes on and meets the criteria, you say, okay, let's see if we can find you an affordable lawyer. And you reach out to, you got a big enough leads coming in. You could have a portfolio of lawyers that will come in. For instance, you could just do like a referral fee and get them to agree to lower their rates for this one case. And you would agree to, give me a call anytime. I'm going to mentor you anyway. I might as well mentor you on a case where someone needs some help.
Yeah.
I don't need to just lecture you on how to do cross-examination. No, come to me and, let's sit down and talk about shop and answer your questions. And you could actually make that into, even like I say, even a sociopath can, want to help others all the time, because it would be just good lead generation for people. If an attorney could structure their law practice where they could help the most vulnerable, those that are shieldless, right? I say every case is a defense case, even a prosecutor, because prosecutors are defending victims from atrocious things and being their shield and protecting their victim rights. Everybody is a defense lawyer. Everybody is being protected. So we can better protect people by better organizing systems and leveraging existing law practices to have a foothold in organizing a way to communicate with people that can't afford you, instead of doing involuntary pro bono for clients that you expected to pay you and didn't. Like, there's an organized way to do it rather than just going to legal aid and offering to do it for free.
Yeah.
Okay, I'm going to set aside this many cases a month to do a sliding scale for somebody that can never afford to pay me everything that you do a discount for. That can be done deliberately if people had systems in place where they had excess time available to help those people, or to advise the attorneys that have the bandwidth because they don't want to be twiddling their thumbs because they got no clients.
And it's staying sharp in court, developing skills.
Ooh, that's a good point too, because a lot of lawyers that don't go to court very much, and their skills get stale. And where's the highest volume of court cases? So it's going to be restraining orders and stalking orders and family law cases. Where's the highest bar complaints and chances for malpractice? Okay, family law cases. So lawyers can't dabble in family law. It's dangerous.
It is.
But clients need people to dabble in all things if they're trial lawyers, because evidence code is evidence code.
Yes.
So there is crossover where people can answer questions. You just have to, like, I get questions all the time from people about something that I learned about in law school. I don't really remember it very well. I'm curious though, and I've never seen it applied in real life. Let me go research that. Mm-hmm. Okay, let me answer your questions, give you some ideas, give you some things to go research. And then when you go, and I'll give you some names of potential lawyers, maybe you go ask them some questions and you're more informed. There's like this, like I mentioned, process literacy is like a lubricant for the quest for the truth, and informing yourself on that process and the procedures and other strategic ideas also doesn't just lubricate. It's like it starts a flame. It's a seed that can be watered. It's a flame that can be fanned, that can thus be transferred to the ultimate lawyer you do hire. So that's why the legal community, as a feedback loop amongst itself, needs to be increased in efficiency.
And two parts to this response, but I watched the state of the court for Lane County yesterday or Thursday for the lunch CLE, and the volume of cases this court was handling was equivalent to Washington County. And Washington County had 2 additional judges, but I was looking at the volume of restraining order, protective order cases. Felonies went down, but the misdemeanors went up, so it's still the same number of criminal cases. There's a volume of these kind of cases that you're talking about just locally in a town where they say there's too many lawyers and it's saturated, but apparently it doesn't necessarily seem to be accurate.
Well, if the supply and demand curve doesn't meet and people perceive there to be an excess amount of lawyers, then there's inefficiencies in that system, meaning that some lawyers are doing practice areas that they can't afford to do and are stuck and not willing to go learn something else, or just don't care. And maybe they are efficient and they're just happy, but a lot of lawyers that are stuck, being a slave to the billable hour, maybe they lack imagination, maybe they lack controls, or maybe they're just on the grind and they're not scaling their knowledge by teaching. So there's process literacy and process lubricant that can be injected into the system, that when lawyers get involved in cases with unreasonable people, they decrease the likelihood of trial. That's what I think a lot of judges miss, like aggressive discovery, aggressive allowance of depositions. Like if there were depositions in criminal cases, guilty pleas would go up, guaranteed, because clients would know there was no hope at trial.
Yeah.
If there was depositions in criminal cases, dismissals would go up. So dismissals increase and guilty pleas increase? Yeah, because you don't have to go to trial to learn what happened. You learn what happened beforehand, then you go convince the other side that they should do X. Therefore, less court resources are wasted. But because we're a victim worship society, judges tend to want to not allow as much robust discovery because they've been jaded by lawyers billing the client just to waste time, and they just don't trust lawyers to do it in an efficient way because, quite honestly, most judges are experts at checkers, and the most competent lawyers are experts at chess.
And they were saying recently at this state of the court that family law cases are taking longer to resolve because they've implemented a system of status checks. to make sure things are flowing properly.
Right, so the cases last longer?
Yeah, because they were boasting that with two less lawyers, they cleared more cases per year in 2025 or 2024.
Two less judges?
We have two less judges in Washington County, but they cleared a number higher than
Well,
them.
that's cool. How'd they do that?
We talk about local customs, and I think we have a rocket docket here where they push things through the system too fast, forgetting about due process for numbers purposes and statistics. And
Okay, so the question is that the best metric? Is the best metric how quickly a case gets resolved?
no,
The answer is no. The best metric is how often do the courts get it right, and how often do they resolve in a way that's fair, and not because you put a gun to someone's head and pushed them to trial before they were ready. That's a huge injustice.
that is.
And one workaround of that, and I think a lot of lawyers miss this. Take a civil case, for example, where not a family law case, you got two reasonable lawyers and they want to postpone the trial out so many months, and court with a rocket docket says, no, it's got to be done in this. I don't approve the postponement. Okay, you go to the other lawyer, you agree to dismiss it until the statute of limitations, and what's the worst cost? You have to refile it and pay a new filing fee or do a motion to reopen that gets denied, and you got to file a new case anyway. Reasonable attorneys will make the docket and timing work. So that, I guess, in essence, is a lack of trust for the local bar, that they don't trust that they're getting the job done, which, may be warranted, because there's a lot of people that don't look at their file, like their tickling system, their task management system is, oh crap, I got a case set for court tomorrow. What's happened since the last court proceeding? Oh, I got to do it right now.
Yeah.
That's, again, not a competency issue. It's not a subject matter expertise issue. It's a systems issue.
And that's why I might compliment what I heard about family law cases taking longer, is because they put systems in place that discovery is happening, production of documents, and all the steps are happening.
Well, because of that's because the status conferences are causing people to touch their files more often, and thus more work is getting done, but they're resolving at a higher rate but a longer period of time because people know all the issues.
And you have to go to court and explain where you're at in the process.
So it's basically a judge playing senior partner, project manager at a law firm.
Yes, because
That is horrible.
Because I believe the judge that was in charge of family law was seeing the issues with
Brilliant.
productions of documents and people not being ready to go. And why is that? Why is it 6 months and you haven't even requested the right documents and you guys are still preparing for?
Okay, so this,
A lot of judges always oversimplify cases. This is just a misdemeanor. This is just a C felony. This is just a family law case. It's more complicated than that, right, in practice. But I think it might have been a good resolution that Lynn County had, where they would set production of document deadlines. So when you were in court, you'd look at the calendar they had on there and say, okay, so you guys need to have finished exchanging documents by this date. And then the next conference, has everything been exchanged? And the judge kept on track of it, Lynn County being a smaller county. But my experience was that was helpful because it kept things moving and less delays. And I think Lane County implemented that. So in their state of the court, family law cases aren't clearing as quick, but we have roadblocks put in place so that
the work gets done.
Work gets done. Yeah.
Yeah. So what you're seeing is there's two ways to solve a problem of unfair trials. Let's just call the problem to be solved an unfair trial.
Yeah.
A lot of people think the problem to be solved is how do you win your case. The way to win your case is to have a fair trial, is to make sure all the relevant facts get presented in the most optimal way. And if the lawyers out there that are meeting the needs of the folks that have the most frequent contact with the court, lower income people, if the lawyers that are in higher demand tend to charge more. Well, they do charge more. So you have to intentionally go and do sliding scales. And the lawyers that are in less demand charge less, and they're in less demand for maybe they're the best lawyer around, they're just bad marketers. Maybe they live in a big city and that word of mouth never got them out. And maybe they're a diamond in the rough. Love those guys. I want them to work here because those are distressed assets, right? That's a bargain. And if a client's lucky enough to find them, God bless them. The Lord's smiling down on them and paving the way to justice. Then you've got the other problem of the lawyers that aren't making enough income, so they gotta take the worst cases and they got to work them in order to pay their overhead and pay their child support and pay their alimony and pay their rent and pay their debt. And so they're scrambling around. So what's the biggest complaint lawyers have of other lawyers? Didn't return my calls, didn't return my messages. And then what can the court do to lubricate that process? Well, they can require status hearings. It's a shame that it has to be done.
Yeah.
But even the best lawyers will have failures in their system. So having a break check, having a guardrail, it increases judicial efficiency, even if it decreases the time to resolution of a case. Because yes, justice delayed is justice denied, but the biggest injustice is a case accelerated is justice denied. Yes. Cases last as long as they take for fairness and equity. I'm not talking adjective equity, social equity, economic equity. I'm talking equity, fairness, right and wrong. Everybody needs a fair shake. Part of that fair shake is getting your case resolved quickly and expeditiously. And so it's a balancing act. So the lawyers have to be trusted to be efficient. You know, like you've got to be able to, that's why reputations matter so much. You got to be able to know who's billing the client just to bill the client and who's the lawyer you love working with. Because the minute you get on the case, you're like, all right, I'm not gonna tell you what the hidden zingers are, but I'm going to tell you a little bit of what I think the weaknesses of your case are, because I know that you're going to come back and tell me, oh no, Mike, you're wrong because of this, this, and this. And I'm like, oh, okay, well, I better go talk to my client, figure that out. Oh, okay, well, you're wrong for this reason. So you've got that relationship of trust, and then you can settle the case without having to go to depositions, or maybe you just have to go to depositions to show your client that, hey, this is a tougher hill to climb than what we thought. And that's another lubricant in that system, right? Relationships with lawyers. That's why you see in like big cities, like we're lucky, to be in Oregon. You can be a big fish in a little pond. You can do stuff around here that nobody would care about in New York, LA, or Miami, and you can make a real difference. You can know your clients. You can know the other lawyers. You go to LA or something, you may not see the same lawyer ever again on a case. And so the asshole factor, I shouldn't say the asshole factor, the unjust asshole factor, because sometimes you got to fight fire with fire, and swing for the kill shot when cross-examination someone's being a prick to you. You got to escalate the conflict to demonstrate to the jury your dissatisfaction with their answers, just like you have to do that with a lawyer sometimes. There's a lot of bad people out there in the world, and some of them intentionally choose to be family law lawyers, for instance, because they've got borderline personality disorder too, which is just code for poor character. So there's got to be a way that the court can hold those lawyers accountable, but also catch them a break, because they are servicing the lowest income people.
Yes.
Like, you got to be compassionate. Even incompetent lawyers with bad systems deserve to catch a break, because they have real life clients on the other side that need to catch a break.
And they're handling people who are at their worst, emotionally, mentally, in these family law cases. So it's a lot to handle, and it makes it harder. Like you're saying, these relationships are important. Different personalities out there, different ways of working with opposing counsel. It should really be more cooperative. I don't know how much I run into the gamesmanship when there's no one around to see you're acting. That doesn't need to happen. It should operate the way you described, with exchanges of information, and then I go back and utilize that, reformulate, discuss, come back, and trying to come up with a resolution that's fair, because no one wins in these cases, right?
Yeah.
If we're talking
Except for
family
the
law,
lawyers. The lawyers will win by making some money.
No, both are going to go in happy. That's the only way it's going to be fair.
Yeah, because someone else in a black robe made a decision that's going to affect them the rest of their life.
My job, and things I explain to people in those type of cases, is if you can work it out and make a decision, you'll heal quicker and have a better relationships than somebody in a black robe who got limited information, and the rules of evidence got in the way of getting information in that would be important to know, but doesn't fit in to get in. And the judge only gave you 1 day to hear this case, and it should have took a week, and you can't afford a week anyway. So it's better to resolve it yourself than through someone in a black robe.
Tell me about a time that you had a pocket memo that helped you out.
Brand new lawyer, Lynn County. They send property disputes to arbitration and support issues. I went to an arbitrator. This attorney was probably a bar number, 25 years old compared to my 1-year-old bar number. And we all know you look up the other person's bar number to see how much experience they have. I knew this person had a lot of experience. So I put the hours in and I was researching, and I finally found just one particular case that talked about if your domestic violence and abuse of a person causes them to have a mental health issue like depression, which reduces their ability to work, that the balance of distribution assets and support can be off balanced, and you can compensate even more for their inability to work. And
you can rebut the presumption of equal contribution.
Exactly. So I found this case. I was there. The lawyer was kicking back in his chair, casual, making arguments. And not only did I embarrass his client who was overvaluing assets, I came up with this argument and he made an argument and I handed it to the arbitrator and him, and I argued the case, and his face was red. He held his head down because in the end she agreed with what I said.
And he didn't prepare for that.
He didn't prepare. He wasn't ready for some wet behind the ear lawyer who has no experience, in using some air quotes, right? No experience. That I knew that I had to put more work in to be ready, and I had that in my back pocket. Before I knew what a pocket memo was, that was my pocket memo case to pull out when he argued, you can't do that. She doesn't work. You can't attribute a less wage to her because she can work full time. The presumption is, minimum wage. Well, no, because of your proven abuse, she can't work because she's got a mental health issue now that pretty much has her disabled at the moment. And I just remember the look on the face and the walk of shame, and I felt pretty good knowing it took more hours, but preparation and being ready is so critical. So even as saying earlier, at some point, even young new lawyers can do really good work. It's all about preparation and being ready for all contingencies.
Well, let's break down the failures that lawyer had. So maybe he didn't know the facts as well, that would be an issue, or maybe most likely he didn't issue spot that fact as being important because he didn't know the law, perhaps, or he didn't know the facts or didn't know the law, and that's a lack of preparation. Maybe he rested on his laurels. Maybe the client demanded that he rest on his laurels and not prepare for the case because the budget was limited. Maybe he begged the client to give him a bigger budget. Maybe he really wanted to go do all this research and do these things, right? There can be 100 factors that influence whether or not the attorney gets the job done. But at the end of the day, any man with any sort of dignity is not going to go to trial unprepared, which is why so many lawyers overwork cases that the client can't afford, is because either one, it's fear. They don't want to look stupid. They have imposter syndrome like every young lawyer has. Oh, I got a law degree, but I'm not a trial lawyer, right? So you want to over prepare and you want to be able to have all the answers. And the other side may not want to prepare because either they're lazy or they think they've got it figured out or they've been ordered not to. So you've got to trust that the lawyer is going to be true to their word and work the case and not work the case and not bill you. But how many times has clients told us, no, I don't want that pocket memo? It's like, all right, you want to do it anyway because you want to win and because you have pride in your work. Yes. One problem I've noticed in the last, let's say 5 years, I don't know if it's the newer generation of lawyers, but they don't seem to care about winning or losing at trial. They don't seem to be ashamed when they get destroyed at trial, where they're a victim in a case or their client just gets completely destroyed on cross-examination. They're either in denial that it was important and surprised by the victory, which is some sort of incompetence or stupidity or willful ignorance, or they don't care, or most likely they're true believers and they really believe their clients or their victim's position. And to me, that's again laziness and incompetence, because if you just ask questions and have time to do it, which like prosecutors don't have time to individualize every case. And so it's our job to individualize every case and go tell them, this is what your investigators missed, this is what didn't get done, and try to convince them to settle it. And if they don't settle it for whatever reason, and for whatever reason is unreasonableness, they don't have a reason other than they don't want to tell somebody no. And why don't they want to tell somebody no? Because they don't want to get canceled. They don't want to get a letter to the editor that this case was dismissed. They don't want to have complaints. They don't want to have bad reviews, maybe. You got to be brave to tell somebody no. You got to be brave to tell the client, this is complete BS. I don't believe it.
This is why a defense case can cost so much money. Cops out there and should be investigating completely, but it's a race to 911. The first person that calls considered the victim. They discount any information provided against the accused by the accusers, and they gather just enough information to get the elements of the law. They write a sloppy report. The prosecutors trust their officers, and with the strike of the pen on misdemeanors, they get a charge with a one-sided testimony presenting evidence to a grand jury. They get an indictment, and none of them are doing what they swore to do as in a public position, which was to uphold the law, the Constitution of Oregon, in the United States, and protect people's rights and find the truth. They leave it to the defense attorney, and it gets expensive because the way we operate is we send out them investigators quick before evidence disappears, before people's minds forget things, before people have time to keep confirming their lies and spreading them. And that's unfortunate, and people don't really understand that, but they didn't do their job properly, and now it's our job to show the truth. And that's a problem, and that is why this can be very costly, is because we're doing the government's work. They should have been seeking out the truth and finding evidence, whether it proves what they claim happened or is exculpatory and proves or is helpful to our client. They ignore these facts. They don't technically look for extra evidence. There's so many cameras on everyone's businesses. They stop when they have just enough to arrest you or get an indictment, and that's it. And that should not be sufficient. Very inadequate and very sad, and we always need to remind our clients it costs because we have to do the job the government didn't do, which was gather all the facts, good and bad, for the case, and then make a proper decision before you try to ruin someone's life.
Yeah, when the biggest problem that we have right now in the criminal justice system, and I've got lots of biggest problems, right? It's a tie for first place. So bear with me when you hear me say this again some other time. But the biggest problem with the criminal justice system is that the prosecutors and the cops have become side pickers, and the defense lawyers stand in the position of being truth seekers. That is bizarre. We have outsourced truth seeking, gumshoe investigation to the litigants themselves, to the accused. And the system can't absorb that because there is no interest that the public has in taxing themselves for paying for the defense of child molesters and domestic violence abusers. And so they come for your neighbor, they come for somebody else, and it's not until they come for your nephew or your son or your sister or your brother or for you that you realize how broken this system is and how you have to pay for it yourself. So instead of spreading out the burden across of everybody and decreasing the number of cases that get charged, which would decrease the burdens on the criminal justice system and save money in the long term, they'd rather just throw a little bit of water on the fire, and that's not enough, so you have to go hire your own fire department to put out the fire. Yep. So what does that mean? That means now you've got to pay to save your life. So clients come to us, ask us, how much does it cost to do a case like this? And the answer is, how much do you have to spend? Tell me how much cash you have available, because cash purchases time and attention. Time and attention increases the likelihood of success if deployed properly, judiciously, and in the right systems. And if you only have X dollars, then this is our recommended line of attack, our recommended battle plan. If you only have 1/2 X dollars, here's what we recommend. If you, what if I had 10X? Well, 10X, we could maybe do a couple other mock trials. We could maybe write that much more detail for trial. We could model our questions better. We could hire jury experts, and maybe that increases your odds from a 90% chance of winning to 92% chance of winning. And it's up to you to decide if that 2% is worth this much money.
Yeah.
Well, how do you know it's a 2% chance of winning? I don't know. It's hocus pocus. I got a crystal ball, which is my pattern recognition based upon my training experience and all the cases I've seen. And when you throw these facts into this system, I think if I had 10 random juries doing 10 random jury trials, that I would always lose one out of bad luck. I'd always lose one because I had a bad day. And we're really just arguing about, another 8 out of 10 cases where the other side will lose once because of bad luck, once because of a bad day. So that's 4 cases just determined by circumstance. And then now you're talking about 6 random juries. What would 6 random juries do? Well, you and I had that trial like a year and a half ago up in a very conservative county in this state where half the jury was woke feminists. And we told that story to one of the judges in there, and he was like, impossible. How can the grass seed capital of the world have a bunch of NPR drones? Well, they weren't actually NPR drones. The one NPR listening person performed very poorly in jury selection, but she was definitely interested in the truth, interested in learning. She just happened to always filter things through the prism that is a certain ideology.
Yeah.
But she was curious, and we left her on the jury. Why? Because someone else that looked better for us seemed less open-minded and thus not a fair juror, so we didn't want them to be a wild card, so we left them on. So we were left with 2 other seemingly bad demographic jurors for a domestic violence case. And the DA left on a domestic violence victim on the jury because of course that's going to be a great juror for her. And you and I were floored because that juror was our best juror, because her complaint was that she was a domestic violence victim and the cops and the DA didn't prosecute her domestic violence perpetrator, and she lost custody, and she had total trauma over the fact that the system let her down. Those people are brutal to liars. They do not tolerate misrepresentations of the truth because they know that someone that's telling the truth, their ability to access justice gets diluted by the liars out there. So the system right now, you've got to focus on who's your fact finder, who's listening to the evidence, and what you can do to potentially alter the outcome by either getting rid of the folks that aren't going to be good listeners, or by programming the folks to think like you want them to think by doing the correct jury selection during voir dire.
Exactly. That's key. That's the start of the case right there. It's the first time we get to talk first as defense attorneys.
Yeah, but not enough preparation for jury selection.
Yeah.
We talk about the ideal juror pretty quickly in a case. We talk about the dangerous jurors you don't want on the jury, and we talk about what we want the jury to think about and how we want them to think about it. And then we talk about the sort of forced choice questions that we can ask that can program their minds, or to learn more about them. We obviously, pretextually, we're trying to figure out who's going to be fair, who's going to not be fair, but also we're trying to train them how to think. That's why we ask them lots of questions about the presumption of innocence. We ask them questions about burden of proof, because we don't want somebody on the jury that's not going to listen to those jury instructions, but also we want to train them how to think about perceiving evidence and think about how they make decisions. So when we give them evidence, they think about the world through the prism that we've put in front of the light.
Exactly. And a misnomer is jury selection, right? It's actually jury deselection, because we get these pools as jurors and we're deselecting the ones that are going to be harmful to the case. And it's very strategic. Every court's a little bit different on how the next juror comes up as we strike jurors, whether for cause or preemptory strikes. But it's a very strategic process. It's great when we have 2 attorneys at counsel table, because we could be reading faces and body language and conferring on things we heard and keeping up. And it's critical those 6 or 12 people we deselect and who are going to remain.
Yeah, I think having a co-chair at trial, or at least an investigator or a paralegal out in the audience, if you don't have the resources for a second chair, is imperative, because it's the unobserved observer who I care about. Yes, I definitely care about the person I'm talking to and the conversation I'm having, but I'm focusing on that person. I'm not focusing on the person over there that's about to vomit in their hands because of something I said and has a a disgusting feeling about maybe the lawyers, maybe the client. I don't know. The unobserved observer matters.
Or that sleeping juror that we had, who was quite helpful, but kept falling asleep and having to be woken up by the clerk and
He worked
offered
graveyard.
snacks. Yeah.
I wonder if he worked graveyard during our trial. He must have.
Yeah, he couldn't stay awake. But obviously I noticed that when you were talking, he was paying attention.
He also nodded at us when he came back after they deliberated, looked at us and gave us a little nod. And then
So as the attorney who's on deck, so to speak, who's paying attention either to someone's direct or doing the direct or doing a cross, that other attorney, co-counsel, second chair, or other person on the team could be watching jurors' faces, like we said, the unknown stuff going on, even paying attention to what the judge is doing.
yeah,
It all makes a difference. And even watching the prosecutor, because as the first chair, maybe doing a opening or close or direct or cross, I'm watching the accuser, I'm watching the prosecutor, and if they're starting to write or do things, obviously we hit a certain button and it's something to focus on, and maybe there's a recess or a note pass to develop something further because we hit something.
I can't even remember the last time that I had a solo jury trial because there's just too much value for having extra set of eyes. If you really break down one of the most important things that a lawyer does at any part of the case, it's intelligence gathering, extracting from the client what is the most important to them and what is most important to the case, and then using that as a tool and to be able to have a relief valve when a client's feeling anxious during the case because perceived the job's not getting done because you're not communicating with them well. Lawyers fail at that all the time. And that can decrease the quality of the relationship and cast doubt. So attorneys, even if they're the best lawyer doing all the work, it's got to almost be like the client sitting next to you while you're working on their case. Hey, I'm getting ready to, I've been looking at this, and this today. Just want to give you an update. And, sometimes what I'll do is I'll describe into ChatGPT everything I've worked on for the last, hour and a half on a client's case and then use ChatGPT to draft the billing entry with all the details so I don't have to sit there and type it out. And then I'll just cut and paste that into the client chat to give them the update, even though 2 weeks later they're going to see it. Because usually I have a question for them, or I just want to, let them know we're taking care of them so they're not sitting at home worrying about their case. I mean, they want their attorney to be working on their case. They don't want to be left in the dark. So even if you don't have anything to communicate to them other than, hey, I researched this today, didn't help. That's fine too. I ruled it out and you care about me enough to pay attention and you care about me enough to tell me what's going on. But then in trial, the feedback loop and the intel gathering is so much more important because everything's at stake. Like you said, a judge starting to get uncomfortable on the line of questioning and fidgeting in your seat. If you catch that out of the corner of your eye, you realize that you're about to get sustained if somebody objects. Or if I'm listening and I'm not the questioning attorney at the time, I know that judge is going to sustain objection, cumulative, objection asked and answered, and shut them down. So you can pivot in trial and be ready for whatever they're doing. And I remember a time when I think it was my first jury trial ever. I was clerking at the DA's office, and our new presiding judge in Lane County gave me a .07 DUI to go try. And I'm like, oh, great, they must really trust me. I didn't realize it was because it was like an unwinnable case that the attorney didn't want to lose. Because back in those days, there was actually consequences to going to trial as a DA and losing because we hadn't got to that victim worship stage where, we'll just go to trial and waste everybody's resources for a 10% chance of a prosecution verdict just so I don't have to tell you no and hurt your feelings. Like the DAs back then, they would have the tough conversations with the cops and the victims and explain to them artfully, maybe they still believe them that it happened, they just tell them why it can't be won. And that stopped happening. So I got this .07 DUI, go to trial, and I was a law student at the time, and there's this juror that's just nodding her head at everything I said. That was the day I learned that active listeners nod, not because they agree with you. That was a very quick not guilty verdict for the defendant because it was a .07 DUI with no signs of of impairment and should not have been tried. It should have been dismissed, but I didn't know any better, and nobody recommended that I do that, and the lawyer responsible didn't dismiss it. And that's just the way it was. Now, I was focusing my closing talking to that person because, I don't know, I got the instant feedback. Probably I should have been reading the room a little bit better, because even when she was nodding during cross or during direct, it wasn't useful data. I didn't know better. I was a young lawyer. So over time, you learn these things. Like you've had previous jobs where you've had to interact with the public. You've been in customer service. You've worked at restaurants. You've been a police officer, a municipal court judge. There's a lot of data points that you have about the human condition. Like Frank could walk into a room and read the room, right? Because he understands how people think. Now that's good just human-wise. And I don't believe that there's people out there with lack of empathy. I think, maybe there are psychopaths, but I think there's just people that don't try hard enough to understand. Like they lack imagination and patience. Like you just have to have a theory of mind. You just have to, I wonder what they're thinking. Okay, well, what would I do in this situation? People just don't take the time to do it. And you realize a lot of bad actors do things because of pre-programming that maybe in different circumstance, I would have done the same. If it was, a violent reaction to a situation, good chance I would have acted the same way. Like you don't learn self-control and discipline when it comes to getting your buttons pushed and disrespected until you get a little older and wiser, which is why you got a lot of miscreants running around out there, because there's nobody getting punched in the face at playgrounds anymore, right? To learn their lesson like I did in sixth grade when I got punched in the nose on the way home from school for mouthing off to the wrong person. Learn a valuable lesson there. There's got to be that feedback loop. There's got to be the communication between the jury, between the witnesses, reading the witness, and it just is so much easier when there's a whole army of jury consultants in the room, if it's an unlimited budget, that are giving you real-time information, or for the budget conscious person, maybe an associate attorney or a partner of the law firm that takes it on a discount where you get two for the price of one, because we all love winning, we all love trials, and we like the client, so let's just go have some fun together, right?
And that's part of where you've done that sliding scale type of thing. Clients invested a lot of money, we invested a lot of time, we believe in this case, and a second attorney might be there assisting at an extremely discounted rate so that we improve our odds in these high-stake trials. People's liberties are at stake.
And there's also selfish reasons too. Trials are stressful. If you're not stressed out at trial, it's because you've prepared everything in advance. So you can mitigate the stress tremendously at trial through proper planning and preparation. And the best way to mitigate that is to have more labor working on a case, so you turn over more rocks, you have more investigative leads, you have more pocket memos, more things reached, more things briefed, more motions researched, right? It's all a function of time. Mm-hmm. But most people can't afford us, and the people that we would be willing to work and help for a discounted rate or for free, we don't really have a perfect system for learning who they are, right? Because when people just take random cases without vetting the facts because they're going to help somebody on a limited income, God bless them. God bless the public defenders out there. We have the luxury of picking and choosing, and we choose to work with people we like and we believe in, right? And I think that is a form of justice lubricant as well, because the better a lawyer is, the higher in demand they are, and the more just the lawyer is and willing to take cases where someone is telling the truth, or most probably telling the truth, and willing to do that at a discounted rate, that is a form of system lubricant as well, because the people that don't deserve your services because they're fucking liars, they get weeded out. Because the intake team's like, yeah, this person's trouble. Yeah. They're cursing at me, they're being rude on the phone. Okay, well, they're not going to be a client here. Maybe they've been wronged tremendously. Yeah. Or maybe we'll jump on the call and be like, look, I'm just going to talk to you for a second, because our intake leader, our intake paralegal, thinks that you're actually been falsely accused, but we can't take the case because you were rude to her. But let me just give you some tips. The next lawyer you call, do not do that.
Yes.
Do not be a prick, okay? We had a client call once, and we didn't have time to handle the case. I could hear Michelle out in the hallway saying, oh, they can't handle a case that's set for trial next week. Oh, my attorney withdrew because of this conflict, because of sexual abuse by the attorney. And I could hear her having this conversation. And I'm like, let me talk to her. I was like, for one, you'll never find a lawyer if you tell them you have a trial next week and the attorney withdrew because you accused them of sexual abuse. That just will never happen, because that's a red flag beyond any I could ever imagine. So, the same thing could be said for someone calling and being rude. Like, look, you were rude to the intake assistant. No, I wasn't. I don't want to get an argument with you. Your tempers are flaring. That's okay. I heard about your story, and I think you can be helped. Won't be here, but you might want to consider this, and this, and getting these documents to your next lawyer and being a little nicer to the paralegal when you call. And that helps the system be more efficient. It increases the likelihood of having access to a lawyer. There's tons of barriers out there that, with little conscientiousness of planning and systems at law firms, could increase the likelihood of people getting the information and the help they need at the time they need it. What do you think is the biggest impediment to access to justice in our current criminal justice system? One of the top reasons that people don't get a fair result. Is it an unfair judge? Is it a incompetent lawyer? Is it because they don't have the cash? What are you seeing out there in the trenches?
I guess it's a combination of the two. Lawyers not competent or overworked, they're volume lawyer, so they give you the bare minimum. As we've discussed, we can go walk in and do a family law case or a basic misdemeanor without much prep. It's the lowest tier, right? That's not how we want to operate, and the people get that. And the other is the cash to afford the quality and attention they need to have something more than minimally competent.
Yeah, because what you're describing is a supply and demand curve brokenness, because if a lawyer needs money, there's a high supply of family law cases and a high supply of low-income cases and these sorts of areas, so they can go dabble in it and go pay the rent.
Yes.
And the question is that better than nothing? Sometimes it's not better than nothing. We've seen cases where lawyers have been disasters. We've seen very competent pro se people win. You can go to the courthouse any day of the week and watch pro se litigants beat lawyers in trial.
Unfortunately, then that comes to the judge question, because a handful I've done where I was up against a pro se, the judges wanted to prevent me from putting on a case because it was a disadvantage because I was skilled and knew what I was doing and what to ask, and would attempt to help the other side. Have to be reminded that you're the judge and a neutral referee after you hear all the facts. You're not here to ask questions because you didn't get the answers to help them in a case. That can become an issue. I haven't had to deal with it more than less than half a dozen times, but
yeah, a judge should not be putting their hand on the scales of justice, tipping it. They should be trying to open up the accessibility of the justice system. And I bet it's real hard for a judge to tell the difference between I'm being unfair, helping out someone, versus I'm just making sure the rules of evidence are followed and they're getting a fair shake. I mean, like a lawyer going in and clearly introducing improper character evidence or hearsay, trying to sneak it in past the other side, and because that lawyer was ill-prepared, and the other side doesn't object, and that particular evidence is questionable and needs to be cross-examined. Mm-hmm. Well, what if the person introducing the evidence is right and that is the truth, and they need it to win? I mean, that's got to be a tough decision for a judge.
I think how many times you and I have said when we have a pro se on the other side of these protective order, stalking order cases, family law cases, that when they get a lawyer, we're like, great, someone who's reasonable is going to be on the other side.
They don't trust us. Sometimes they do. Sometimes you get a good relationship going with the pro se person. But most, like you said before, that family law clients, family law litigants are good people acting their worst.
Yes.
Criminal defendants are often bad people acting their best because they've hit rock bottom and they've learned, and they may be falsely accused, they may be honestly accused of something. They're not innocent of everything. They've done something to tick off somebody so much that they lied about them. So they probably haven't been living the best life, but they're in good behavior now because they need the help. Where on the other hand, family law parties are often very skeptical of the other lawyer. Mm-hmm. And so if they could just get someone they trust to ask questions to, like, this is the proposal I got, is this fair? Oh yeah, this is fair. Oh, okay. Now I just opened up the judicial system for one less trial. And people go away happy because they made the decision rather than a stranger in a black robe.
That's what I tell them all the time. You guys make the decision. You'll be able to co-parent better and heal quicker than a judge sitting up there making changing your whole lives. Another thing I always say when they come to me, do you win a lot of cases? These are custody family law cases. I'm like, I win them all. You're going to get a divorce. And I say, but guess who loses? And they're always like, who? I go, your kids. That gets a pretty impactful silence from me and them. And they understand the seriousness and who I am as an attorney when I tell them who loses. They really didn't think about that.
That's because lawyers are influencers. Our job is influence juries, influence judges, influence the other side, influence the other party to settle, but also to influence our clients to make better decisions and influence our clients on how to survive a case like this because they've hit rock bottom.
I had a client who some come back and tell me they listen to me, and one came back and said, when we first met during the consultation, you told me that you'll be able to help me for one day in my life, which was my trial date for family law and custody, but that she needed help for the rest of her life to process this, her future, and all the choices she made that led up to that. And I suggested she get counseling just to go through that whole thing. And in the end, she told me, and hadn't told me until we were done, that she had gone through counseling through the whole process, and it actually was helpful. So when people actually listen to me and give me that feedback, it just, I feel better about it. Like, you actually took my advice, because I'm like, I'm helping you out one day. You need help with your whole life because I know the facts. You spilled your heart out to me. You told me your past, and sometimes there's patterns, and they're being repeated. And I make that recommendation. Everyone listens to me.
You're a problem solver. You've got enough data points that you know when people do these things, have these problems, and don't do X, Y, and Z to solve it, they tend to fail over time. And just like referring a client out to another attorney that's more competent in that subject matter, or more affordable, or whatever the reason for the referral is, that we trust them, you're vouching for that other person. And in essence, the recommendation I'm making you right now for how to amend your life and live better, I'm vouching for that way of life because either I've lived it or I've seen other clients go that direction and it's worked. People are looking for solutions to problems when they call lawyers. Mm-hmm. They're looking for somebody that they trust to guide them through a system that's just ripe with risk around every corner, unknowns, uncertainties everywhere. People are afraid of the pain point that could happen. They're experiencing pain right now, and they're afraid of the worst case scenario. And the only way they can solve those problems right now is with more information from someone they trust. And lawyers that go out there on the front lines are meeting with clients and answering questions, and they're doing God's work because they are calming people down, getting them out of that emotional state, getting them into that pragmatic state of problem solving. And even by just doing a quick consult for a fee, maybe all they need to redirect themselves to being more productive, making the better decision for their kids, making the better decision on what type of lawyer to hire, or if they go to trial by themselves, they've learned a little bit about what the judges care about, and the access to justice increases by virtue of the information that was given away for a fee or for free. So I really appreciate the time today talking about this stuff. We should do this again soon. I think that the next time we talk, we can go on some of these other little branches of what ifs and maybe get some more of the commonly asked questions answered. What do you think would be good for the next conversation?
Maybe something on what to look for in an attorney you want to hire.
Yeah,
what questions to ask?
What questions to ask? What questions to ask an attorney? What should an attorney be doing on such and such case? What I'd like to see is us spend some time walking through. Like, I see a hole in the attorney-client system. I see it every Monday at court in Lane County, and it's pro se people fighting over their kids or going to restraining order hearings or stalking order hearings. And either they haven't had time to hire a lawyer because of the process and the limited availability, nobody's available. So maybe they need to be taught how to ask for a postponement and what to do if the postponement doesn't get granted. And then what witnesses to call, what evidence to do, how to prepare for cross-examination, what to say in an opening statement, what to expect, Do I sit? Do I stand? What do I say? How do I address the court? I would like, if I know what I would want if I was out in the wilderness with a court date that's going to affect me for the rest of my life. I would want to know everything. Just like, I'd want to know the battlefield. I'd want to know before a rugby match what the pitch is like. If I slide to pick up a loose ball, am I going to, skin my knee and my shin and wipe off all the flesh? Okay. Is the tri-zone on the hill? I once played a match where the tri-zone went off like a cliff, basically. So you had to count for that if you were on that right side of that end goal. If you jumped too far, you would go over the back of this 5-meter hilly tri-zone. Like, you got to know the battlefield. And education and information is the only way for a client to do that.
We could also at some point talk about current changes in laws. We talked about helping people understand some of the processes, like the immediate danger order. They just changed the rules. They lowered the threshold of what you have to prove. But there's a whole process that would be interesting.
Yeah, what I'd like to do is take the things and give it away to other folks. So if they want to hire you, they know you better. And if they can't afford to hire you, they can't get access to us because of schedules, they at least know what to ask the next lawyer.
And one of the things you might not ever be able to know about an attorney unless you see them in trial, and is something that I think is innate in people, or they develop that skill because they're in the proper profession for them. And something Mike talked about earlier in trial is reading the room, reading a witness you're examining, and being able to change and pivot, be able to handle objections. I see prosecutors, and I've seen other attorneys in family law cases just freeze because they don't know the next step. They weren't ready for an objection or for someone to change on them, become a hostile witness, or just a body language changing enough that you change your tone and attitude or the way you question someone.
Yeah, you don't want surprises. You want to be able to pivot.
That's either someone who learned that skill through many trials or someone who's got a lot of life experience and understands people, because that's a key part to trial. And, we watch prosecutors, they're not really especially prepared, and all they do is say, tell me what happened next.
And they don't seem to understand the human condition. Like, they don't seem to understand that a juror is going to come back in 12 minutes not guilty. Like, we had a 14-minute not guilty verdict, then we had a 28-minute not guilty verdict, a 45-minute not guilty verdict. I think I've only had one criminal trial that was over an hour deliberations. We had a 45-minute manslaughter not guilty verdict. To me, that's not exceptional lawyering. That's like a failure on my part not to be able to convince the DA or the accuser how shitty their case was. Like, I missed something. I missed a way. Like, I'm always so disappointed. Like, this is so obvious. This is a total ass kicking. We've got all these inconsistent statements, these motives to fabricate. How can I? Well, you just can't. Sometimes you just can't convince the other side, and you have to go to trial. So you've got to be able to go to trial with a lawyer you can trust. And the reason that I work with you, Frank, the reason I trust you with everything I've built and with my clients and with my time, is because you have skills that are very valuable. Like, you're able to read people. You're able to understand the human condition to a point that you can predict what they're going to do, and then you can back extrapolate to what they have done to why they did it, and thus able to put together a case. That, plus your attention to detail and your ability to manage people, which probably comes from chaotic kitchen environments, managing people as a short order cook, or your time in law enforcement needing to manage a bunch of calls as they come out on the through dispatch. You got to be able to move quick. You got to be able to ascertain a situation, then move on to the next call and clear it. Right? I mean, you've got to understand the human condition. You've got to have systems, and you've got to have passion, and you have all those things. So when those are all put together in a way that can maximize client chances of victory in the most affordable way, and that's the perfect day. That's like our goal here. Every attorney's goal should be this: is to make a client into a former client as quickly and inexpensively as possible. Sometimes it's very expensive to do that, because a little effort done now, because you understand the lay of the land and you can predict things through pattern recognition, makes it a lot of work right now, but decreases the chance of trying it because you were able to influence the other side. through the facts, through logic, through reason, through narrative skills.
And you say expensive, but choosing the wrong attorney and doing it wrong to start, and then coming for us to do damage control and then execute the proper plan is even more expensive.
That is
Not
true.
only financially, but with your life, your emotion, your spirit. There's a cost to having a deal with a legal problem, and it's more than financial. So picking the right attorney first, even if it is expensive, is still the cheapest route.
No, I really appreciate your time, Frank. Frank Segarra, pleasure to work with you. Pleasure to watch your career develop over the years, and I'm very grateful that our clients have a chance to work with you and get the answers they deserve.
Thank you.